And now let's dive into some of the legal questions behind all of this and similar moves by the president in other cases. We're joined now by Mary McCord, a former federal prosecutor, now executive director of the Institute for Constitutional Advocacy and Protection at Georgetown University. Mary, it's always good to see you. So Jeanine Pirro, who is leading this criminal investigation as the U.S. Attorney for Washington, D.C., longtime Trump ally, what are the standard guardrails when the appearance of a political conflict of interest is this intense?
This is Dr. John. Welcome. The top federal prosecutor in D.C. just filed 112 pages of charges against Trump, demanding he be taken into federal custody immediately upon conviction, with a court hearing already set for 3 days from now. This isn't a slow legal process. It's moving fast.
A judge has sentenced President-elect Donald Trump in his hush money case, but declines to impose any punishment.
And WGN Shannon Halligan is here to break down why Trump walked away despite the felony convictions.
Yeah, Trump will enter the White House now without the threat of a jail term or a fine related to this case. However, it cements the first criminal prosecution and conviction of a former U.S. president.
This is not speculation. This is not a cable news talking head-making predictions. This is Matthew Graves, the United States Attorney for the District of Columbia, operating under the full authority of the federal court system, submitting a formal legal brief that states in the language federal prosecutors use when they mean business that post-removal custody is mandatory.
After weeks in court last May, jurors found Donald Trump guilty on 34 counts of falsifying business records. On Friday, a judge sentenced the president-elect, but declined to impose any punishment. The sentence came just 10 days before Trump's inauguration.
The only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge.
Manhattan Judge Juan Merchan could have sentenced Trump to up to 4 years in prison. However, the judge said he had to consider other factors, like the legal protection Trump will have as president.
The considerable, indeed, extraordinary legal protections afforded by the office of the chief executive is a factor that overrides all others.
The word mandatory appears in a 112-page federal filing on the same day the House is moving toward an impeachment vote with a 227 to 208 projection. And within hours of that filing becoming public, the predicted jail odds spiked to 65%.
Trump addressed the court virtually from his Florida home. He called the case a weaponization of government.
This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work.
When asked about the sentencing, White House officials declined to comment.
What can we do to continue to deliver for the American people? What can we do to make the lives of the American people better? And that is our focus, not going to speak to the decisions made in the court today.
Despite the no penalty sentence, the judge said that doesn't erase the 34 felony convictions.
Despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict.
The hush money case is only one of 4 criminal indictments against the president. It is the only one that went to trial and possibly the only one that ever will. Ray and Micah.
Thank you, Shannon.
65% odds of a former president going to federal prison. That number in a legal market on the same day as the impeachment vote. On the same day, the Attorney General's position collapsed. On the same day, the Epstein files were circulating with the president's name appearing 6,000 times. On the same day, the 25th Amendment odds hit 60% with 10 cabinet secretaries wavering. Here is what makes this filing categorically different from every other legal development we have covered. The impeachment, the Senate conviction odds, the 25th Amendment projections, all of those are political mechanisms. They involve votes, they involve calculations, they involve members of Congress deciding which way to go based on their constituencies. Political mechanisms can be influenced, political calculations can shift, political outcomes have uncertainty built into them by design. Federal prosecution does not work that way. A 112-page brief with 18 exhibits filed by the D.C. prosecutor is not a political document. It is a legal document document. It lays out charges, evidence, statutory citations, and a specific requested outcome. The judge who receives that brief is not making a political calculation. The judge is evaluating the legal sufficiency of the argument, and a federal court hearing scheduled for 3 days from now means a federal judge has already determined the filing warrants a hearing. That is not symbolic. That is the machinery of federal prosecution engaging audibly in real time. This is the moment the legal track and the political track converge into the same destination, and that destination now has a court date attached to it. Let me break down what is actually in this 112-page brief, because the specific legal claims Graves is making are the foundation of everything that happens from here, and the details matter in ways the headline numbers alone do not capture. Graves is making 3 distinct and separately documented arguments that together build a case for mandatory post-conviction custody. The first claim is Iran war perjury under the federal false statement statute. What Graves is alleging, with declassified memos attached as exhibits, is that the military strikes bypassed Congress without the legally required authorization, and that representations made about the legal basis for those strikes constituted false statements to federal authorities. The declassified memos are the key piece here, because declassified means they are now part of the public record and part of the court record simultaneously. They cannot be reclassified. They cannot be sealed back. They are in the brief, they are in the exhibits. And what they show, according to Graves, is that the strikes were executed without congressional authorization, and that the administration knew this at the time representations were being made about the legal basis for the operation. Think about what that means in the context of everything else we have been covering. A Pentagon official resigned and wrote in his letter that there was no imminent threat from Iran, that the Iraq playbook was being repeated, that the decision was driven by lobby pressure rather than genuine threat assessment. And now Graves is filing declassified memos showing the strikes bypassed Congress. That resignation letter and the Graves brief are corroborating the same underlying claim from 2 completely different directions, from the inside of the administration through the resignation letter, and from the federal prosecutor through the court. That convergence is not accidental, and the judges evaluating this material are going to see that convergence clearly. The second claim is Epstein obstruction, and this one connects directly to everything that has been happening with the Justice Department. Because the Epstein file redactions, the deliberate protection of co-conspirators that members of Congress have been accusing the Attorney General of, those redactions required decisions at the executive level. And Graves is alleging in this brief that the obstruction of the Epstein subpoenas, the defiance of congressional demands for unredacted documents, rises to the level of criminal obstruction involving the president directly. The president's name appearing 6,000 times in those files, combined with the unredacted victim claims now included in the exhibits, combined with the documented history of subpoena defiance, gives Graves the evidentiary foundation to make this claim in a formal federal filing with 18 exhibits attached. The third claim is the unauthorized military strikes themselves. The execution of a military operation of that scale without the War Powers Act compliance that federal law requires. This is a separate statutory violation from the perjury claim, though they are related, and it is the one that carries the broadest constitutional implications, because if a president can authorize billions in military strikes without congressional authorization, and the federal prosecutor can document that the authorization bypassed the legal requirements, the constitutional framework governing executive war powers has been violated in a way that has criminal as well as political consequences. Now here is the piece that is not getting enough attention in the initial coverage of this filing. Graves did not file this brief in isolation. The coordination is explicit in the document itself, with the removal order from another federal judge and with the contempt mandate from yet another federal judge. 3 separate federal legal actions, 3 separate legal authorities, coordinated to land simultaneously on the same day as the House impeachment vote. On the same day, the Attorney General's position collapsed. On the same day, the 25th Amendment odds reached 60%. That coordination is the most significant structural element of the entire filing, because it means the federal legal apparatus, the prosecutors, the judges, the contempt proceedings, are operating as a coordinated system rather than as separate independent actions that might move at different speeds and produce contradictory outcomes. When Graves says post-removal custody mandatory, he is not making a unilateral claim based solely on his own brief. He is making a claim that is architecturally supported by 2 other federal federal judicial action simultaneously. The three documents form a legal structure, and legal structures built by federal prosecutors and federal judges operating in coordination are not dismantled by a social media post or a surrogate press conference. The court hearing date 3 days from now is the concrete timeline that makes all of this immediately real in a way that projections and odds do not. A federal judge scheduling a hearing 3 days from now means a federal judge has already evaluated the Graves brief and determined it is legally sufficient to warrant court time. Judges do not schedule hearings on frivolous filings. The scheduling of the hearing is itself a legal signal that the court has looked at 112 pages and 18 exhibits and decided this proceeding needs to happen on a specific date with the parties present before the bench. And the 65% predicted jail odds are the legal and political community's real-time response to that signal. Prediction markets are not news outlets making guesses. They are aggregated probability markets where people with money and legal and political knowledge put actual stakes on outcomes. When those markets move to 65% on the question of post-conviction federal custody, it means the people who follow these proceedings most closely, who read the filings, who understand what a hearing date 3 days from now means, are pricing a very specific and very serious outcome at 65% probability. Let me connect the Graves filing to the full political and legal picture because it does not exist in isolation. The Supreme Court immunity denial earlier this week removed the legal shield the administration had been counting on as a backstop against exactly this kind of prosecution. That denial was not just a political setback, it was a legal door opening. It removed the argument that presidential immunity bars prosecution for conduct undertaken while in office. And Graves filing this brief days after that immunity denial is walking through that door with 112 pages and 18 exhibits. The Supreme Court denial and the Graves brief are legally connected. The denial created the prosecutorial pathway. The brief is the first major filing through that pathway. The removal order we covered earlier this week is now directly cited in the Graves coordination, meaning that document was not a standalone signal. It was the judicial component of a coordinated legal architecture that Graves has now made explicit in his filing. The three documents form a triangle of federal legal pressure that is now publicly documented and court-filed. The Attorney General's story, the bipartisan perjury accusations, the subpoena defiance, the obstruction theater characterization feeds directly into the Epstein obstruction claim in the Graves brief. Because the documented pattern of Justice Department conduct, the redactions, the subpoena defiance, is part of the evidentiary record that Graves is using to support the obstruction claim against the president directly. The Attorney General's conduct is not a separate story from the Graves filing. It is exhibit material for the Graves filing. The 25th Amendment odds moving to 60% on the same day as the Graves filing tells you something critical about how cabinet members are processing the legal developments. Because cabinet members considering the 25th Amendment are now not just evaluating the political situation. They are evaluating whether to remain in an administration that a federal prosecutor has filed a 112-page brief demanding be taken into custody immediately upon conviction. That is a fundamentally different calculation than the one they were making 48 hours ago. And 60% odds with 10 secretaries wavering means that calculation is moving fast toward a threshold. The Graves brief is not a political document. It is a federal prosecution filing with a court date. And that distinction changes everything. Every other crisis we have covered this week, the impeachment, the conviction odds, the 25th Amendment projections, all of those involve political mechanisms with political uncertainty built in. Members of Congress can change their votes. Cabinet members can reconsider. Political outcomes have variance. That is how political processes work by design. Federal prosecution does not work that way. Graves filed 112 pages with 18 exhibits in federal court. The court scheduled a hearing 3 days from now. Those are not political events. They are legal events. And legal events, once they are in the federal system, do not get resolved by a social media post or a surrogate making the rounds on cable news the next morning. They get resolved in courtrooms by judges on the record with attorneys present. The 65% jail odds combined with the hearing date 3 days from now means the legal community has already priced this outcome. Prediction markets at 65% post-conviction custody odds are the aggregated judgment of the people who follow federal federal prosecution most closely, who read the briefs, who understand what scheduling means, who have priced in the Supreme Court immunity denial, the coordinated judicial actions, the contempt mandate, and the 18 exhibits attached to the Graves filing. That 65% is not a media estimate. It is a market signal, and markets move on the actual legal content of what has been filed, not on political spin. The hearing 3 days from now is not a distant legal proceeding scheduled months out that might be delayed or maneuvered around. 3 days with a federal judge presiding, with Graves presenting the 112-page brief and the 18 exhibits in open court, with legal arguments about mandatory post-removal custody being argued on the record. Whatever happens in that courtroom, it happens while the Senate trial is simultaneously moving toward an 85% conviction projection. And whatever the Senate does, the federal court is operating on its own independent timeline that the Senate outcome does not pause or reset. The 25th Amendment at 60% odds on the same day as the Graves filing means the cabinet is now making a legal calculation, not just a political one. Before the Graves filing, cabinet members wavering were making primarily a political calculation. They were evaluating the impeachment odds, the conviction odds, the midterm math, the public perception damage, the institutional integrity questions. Those are all political and institutional factors. They matter, but they have variance. Political situations can change. The Graves filing is a legal factor that does not have the same variance. A federal prosecutor demanding mandatory post-removal custody in a 112-page court brief is a legal fact. A hearing 3 days from now is a legal fact. A coordinated filing structure involving 2 other federal judicial actions is a legal fact. Cabinet members evaluating the 25th Amendment are now looking at a situation where remaining in this administration means remaining in an administration that a federal prosecutor has publicly and formally stated should be taken into custody upon removal. That is a different calculation. That is a legal exposure question, not just a political survival question. And 60% odds with 10 secretaries wavering means the threshold is close enough that the legal factor Graves just added could be the weight that crosses it. Here is the complete picture right now. A federal prosecution brief demanding immediate post-removal custody filed by the D.C. prosecutor with 18 exhibits, 3 coordinated charges: Iran war perjury, Epstein obstruction, unauthorized military strikes, explicit coordination with 2 other federal judicial actions. A federal court hearing already scheduled 3 days from now. Predicted jail odds at 65% post-conviction. 25th Amendment at 60% odds with 10 cabinet secretaries wavering. Senate conviction odds at 85%. House impeachment vote projection locked in. Attorney General facing bipartisan perjury accusations and impeachment articles simultaneously. Epstein files with the president's name 6,000 times and unredacted victim claims in the court exhibits. All of it building. All of it connected. All of it converging on a courtroom 3 days from now, where a federal judge will hear arguments about mandatory post-removal custody of a sitting American president. The political track and the legal track have now merged into the same destination. And that destination has a court date and a 65% probability. And a federal prosecutor with 18 exhibits ready to present to a federal judge on Wednesday morning. Watch this space, because 3 days from now is going to be unlike anything this country has ever seen in a courtroom.